Hi guys, our group topic is language instruction policy, and my part is Castañeda versus Picard and California Assembly Bill 507. So let me jump to my slides. The case of Castañeda versus Picard was first tried in the United States District Court for the Southern District of Texas in 1978. This case was filed against the Raymondville Independent School District (RISD) in Texas by Roy Castañeda, the father of two Mexican-American children. Mr. Castañeda claimed that the RISD was discriminating against his children because of their ethnicity. The district court ruled in favor of RISD, claimed that the policies and practice of RISD did not violate any constitutional rights of the plaintiff class. Apparently, the plaintiff class was not happy about results, so they filed for an appeal to the United States of Appeals, arguing that the district court made a mistake in its ruling. So, specifically, plaintiff charged that the school district unlawfully discriminated against them by using an ability grouping system for classroom assignments, which was based on racially discriminatory criteria. The plaintiff alleged that the RISD deprived them of rights secured by the 14th Amendment, Title VI of the Civil Rights Act, and the Equal Educational Opportunity Act of 1974. So in order to know what's going on there, we need to know what's the act about. The EEOA, the Equal Educational Opportunity Act, states that no state shall deny equal educational opportunity to any individual on account of his or her race, color, sex, or national origin by the failure by an educational agency to take appropriate action to overcome language barriers that impede equal participation by its student in its instructional program. So, in this case, the court has three challenges. First, the EEOA did not define the term. So, the open-ended appropriate term does not define what is required to state a claim, what type of litigation plaintiff may take. And the Congress provided little guidance to interpret the term, and there was a small legislative record. Therefore, the court looked to the plain meaning of the code itself, as well as the historical context in which the act originated. First, the plain meaning, according to the court, the Congress decided to use the term appropriate action rather than bilingual education, demonstrate its intent to leave school substantial amount of latitude in choosing the programs and techniques they would use to meet their obligation under EEOA. And at the same time, Congress enacted the EEOA. It passed the Bilingual Education Act of 1974, which established the federal funding for the development of bilingual education program. So based on the reasoning, the court adopted a three-part test to determine whether school districts are providing appropriate action which overcome language barriers in instructional programs. The first key word is theory. So it requires that the program must be based on a sound educational theory. And second, the program must be implemented effectively with adequate resources and personnel. So it focuses on practice. And the third and final one is the results. After a trial period, the program must be evaluated as effective in overcoming language handicaps. If we visualize it in a pie chart, it looks like this. So the three parts work together to determine the adequacy of programs for ELLs. So we would not expect an act or assessment can solve all problem because everything is not perfect. So we may want to ask, is the three-part test powerful enough to force the schools to address the language barriers? So here we have some shortcomings of the Castaneda test. In terms of the theory, nearly all the program can be justified by an educational theory. As long as the school has an educational theory with the backing of at least one expert, the theory will be deemed sound. And the court will not get into the business of weighing educational theory or weighing the credibility of expert. So the court decisions have placed the entire and huge burden on plaintiff to effectively disprove the first prong. And the second part, the practice part, is this part looks at whether schools are have used adequate practice to effectively implement the language program. However, if the school failed to recruit adequate staff, it is excusable when it is due to a lack of resources. And the third and final one, it requires courts to determine whether the program is effective in addressing the language barrier. However, the Castaneda test, three-part test, provides no guidance in determining what standards a court should use in evaluating, and so that makes it hard to define what result would be deemed sufficient. And after a trial period, because the trial period could take a year, so the student may be harmed already before inadequate programs are identified and rectified. So I would like to talk more about ability grouping because that's why the plaintiff think their rights were violated, and I think it's a very controversial topic even in today. So RISD employs ability grouping system, which will place students in particular ability group labeled as high, average, or low, based on the four requirement: achievement test score and the recommendation of school counselor. The court think the ability grouping of student is not per se unconstitutional as long as it is motivated by educational concerns, not discriminatory motives. However, if the school district has past history of discrimination, the practice of ability grouping is subject to much closer judicial scrutiny. So let's take a look at the RISD's ability grouping system. Although the district court failed to make findings concerning the RISD history, the statistical results of the ability grouping show some other perspective. So in the Raymond-Dewell, in the school district, for example, in grades kindergarten through 3, during the academic year 1977 to 78, Anglo students formed approximately 17% of the student population at the elementary campus. However, 41% of the students in high ability classes for those grades were Anglo. Thus, there were approximately 2.4 times as many Anglos in high ability class as there were in these grades as a whole. Also, the record suggests that in the school in Raymondville, ability grouping is intertwined with the district language remediation efforts. The record indicates that the primary ability assessed by the district is English language proficiency of student. The student entering RSD kindergarten classes are given a task to determine whether their dominant language is English or Spanish. Predominantly Spanish-speaking students are placed in low group and receive intensive bilingual education instruction, and high groups are those composed of students whose dominant language is English. So the ability group for first to third grade are determined by three basic factors: school grade, teacher recommendation, and scores on standardized achievement tests. However, the tests are administered in English. The test cannot be expected to accurately assess the ability of a student who has limited English language skill and besides, those students have been receiving intensive instruction in another language as part of bilingual education program. So here is a video. I really like you guys to see it, but basically it's an overview of the case and the impact of the case.
The Supreme Court establishment of the right to an ESL program in Lau versus Nichols was a very important development in the law for English learners and immigrant students and families. The federal court system also looked at the issue of what constitutes a legally sufficient ESL program. So just having the right to that program, of course, was not enough. It's important that the program be substantive and allow access to both content and learning English. The case of Castaneda versus Picard, which also originally came out of the state of Texas, establishes a three-part test. And that three-part test is also found in U.S. Department of Education regulations, which bind all districts that receive any federal funding. The Castaneda Court, which was a U.S. Court of Appeals, which is the step before the U.S. Supreme Court, established that three-part test in the following manner. It said that a district had to adopt a sound approach to the education of children who were English learners. It had to reasonably implement that approach, and then it had to monitor that the approach was working. That's a very straightforward set of tests which can be applied to any school district's ESL program. Since we have a lot of testing these days in public schools, it's not very difficult to determine whether or not a child is making progress in both English language proficiency as well as in the content curriculum.